Thank you everyone for being here. Apologies for all the emotions you might have experienced, particularly what you experienced over the past few hours with all the changes, the votes, assigned seats, unassigned seats, reassigned seats. So thank you everyone for your kindness and for your indulgence. I will now call the meeting to order, meeting number 36 of the House of Commons Standing Committee. We are meeting today to study Bill C-22, an act respecting lawful access. First of all, I would like to welcome the witnesses. The ministers will join us in about an hour. We have senior public servants from the public service. We have Mr. Ramsey Rashev, Executive Director of CSIS, Kimberly Gibney, Norman Wong, Anne-Marie LaBelle from the Department of Justice, Shannon Hagel, Mike Maguire, and Samson O from Public Safety and Emergency Preparedness, Richard Burchell from the Royal Canadian Mounted Police. We will start with opening remarks from Mr. Maguire. 5 minutes, please. You have the floor, Mr. Maguire.
Chair and honourable members of the committee for having us here today. My name is Mike Maguire. I'm the Director General of International and Border Policy at Public Safety Canada, and I'm pleased to be here with colleagues, as was just mentioned, from the Department of Justice, Public Safety, the RCMP, and CSIS to answer technical questions on Bill C-22, an act respecting lawful access. Lawful access is a familiar issue that has been studied by Parliament in the past, most recently by the National Security and Intelligence Committee of Parliamentarians, who issued a special report last year calling for lawful access legislative reform. Le projet de loi C-22 vise à combler...
Bill C-22 seeks to address fundamental and well-documented gaps in Canada's legal access framework. The online environment has facilitated or even encouraged communication, coordination, and concealment of criminal activities and those of threatening actors. The widespread use of mobile devices, internet-based communications, messaging platforms, and other emerging technologies has fundamentally transformed the way crimes and threats to national security are planned, executed, and investigated. At the same time, Canadian police services and CSIS are facing growing challenges in quickly obtaining information essential to investigations. Bill C-22 seeks to address these challenges while maintaining solid safeguards, including respect for the Charter and the protection of Canadians' privacy.
Bill C-22 are grouped under two key themes. First, Part 1 of the bill modernizes Canada's legal authorities to support police and CSIS in obtaining timely and lawful access to digital information needed for investigations, with each tool carefully designed to take into account the type of information that will be collected and the privacy interest it engages. This includes the creation of a new confirmation of service demand, which would allow police to confirm whether a telecommunications service provider offers or has offered service in relation to a specific identifier, for example, a specific telephone number or IP address. The scope of this tool has been deliberately limited to a yes or no confirmation and to telecommunication service providers only. Part 1 would also create a new production order for narrowly defined subscriber information, such as name, address, and basic information about the services provided, and update existing search warrant powers to better reflect computer searches. In addition, it would establish new authorities to facilitate lawful requests from Canadian law enforcement to foreign electronic service providers and enhance international cooperation in criminal matters involving electronic data. These measures are intended to ensure that where lawfully authorized, investigators are able to act in a timely and effective manner, bearing in mind that delays can result in serious and ongoing harm to victims in particular cases and circumstances. La deuxième partie du projet de loi établit
Part 2 of the bill establishes a clear and modern legislative framework to ensure that electronic service providers have the technical capabilities necessary to effectively respond to lawful access requests, that is, access that has already been authorized under existing laws, such as the Criminal Code or the CSIS Act. Canada is currently the only Western democracy without a comprehensive legal framework requiring electronic service providers to develop and maintain such technical capabilities, with the exception of an outdated licensing regime dating back to the 1990s. Cooperation in this area remains largely voluntary and uneven. Part 2 of Bill C-22 would establish minimum technical capability requirements for major providers aligned with international standards, and will grant the Minister of Public Safety the authority to issue targeted and flexible ministerial orders when specific capabilities are needed to meet operational requirements.
to this new framework are embedded in the bill. For example, ministerial orders would be subject to approval by the Intelligence Commissioner and proactively reported to NCIRA. Privacy and cybersecurity considerations are explicitly included in the legislation. Data retention obligations are restricted, and public annual reporting is required. This part does not create new powers for law enforcement or CSIS to intercept communications or obtain information, nor does it allow direct government access to electronic service providers' systems. It also explicitly prohibits the creation of systemic vulnerabilities to ensure that a regulation or ministerial order does not weaken encryption or create backdoors. Finally, Part 2 establishes tools to promote compliance, including inspections and administrative monetary penalties. Pris dans leur ensemble, ces mécanismes visent à
Taken together, these mechanisms are designed to ensure that Canadian law enforcement and intelligence agencies have the tools they need to carry out their important work while maintaining strong accountability and transparency. Mr. Chair and members of the committee, my colleagues and I look forward to answering your questions.
Merci, Monsieur Maguire.
Thank you, Mr. Guaya. I'll give the floor to Mr. Caputo, 6 minutes.
Very much, Chair. Thank you to all of our witnesses. It's so great to have so many people around the table on such a complex issue. We're going to get to know each other very well in the coming 2 parliamentary weeks. I never know who to direct my questions to because there is a lot of expertise here. So whoever is the best to answer this, please let me know. I've looked at the definitions. I've looked at the definitions of, say, systemic vulnerability, how it incorporates the definition of encrypted data to some degree, and the systemic vulnerability, the provision that says a service provider in Part 2 does not have to do anything that would create a systemic vulnerability. I'm going to ask a very direct question. Will this bill cover encrypted data? And secondly, is it intended to be that way? I assume that that would be yes, but will this bill cover encrypted data? Can somebody please help me with that?
Thank you very much for the question. Shannon Heigl, Director General, National Security Policy at Public Safety Canada. The bill is, in fact, encryption neutral. So we want to make sure that where encryption is used, there's different ways that encryption can be used and different ways, pardon me, that that companies employ it. So therefore, we don't want to leave out the possibility for those companies that may employ encryption where there are keys available and can be decrypted in a simple fashion.
Okay, so, but with all due respect, Ms. Hagel, you say where keys are available. This bill, as I read it, would require for a key to be available, would it not?
Some companies already employ a type of encryption that where they have the key. So that we're not asking for keys to be made if there is a company who already has one.
Okay, perhaps we're on different planes here, because my understanding of Part 2 and reading it, particularly in Section 2, it talks about a base level at which providers need to come up to. Am I making sense so far?
Yes.
So if providers need to come up to that base level, and they're not there yet, how do they not then have to create a key to come up to that base level that Section 2 says they have to come up to, or Section 5, I should say? Does that make sense?
Yeah, so, I mean, you're talking about somebody coming up to a level where they don't even have encryption? That's what I'm hearing you say.
No, where there is a service of encryption provided. Okay? My question was, will that provider of encryption, so Company A provides an end-to-end encryption service in messages, okay?
Understood.
Will this bill require Company A to create some sort of mechanism by which that data can be intercepted and by which the government can the state, when I say state, I think you know what I mean, by which the law enforcement can access that encrypted data? Is that clear?
Absolutely. So if there is a Company A that has end-to-end encryption as part of its business service and its model, we are not forcing a company to decrypt that communication.
Okay. So, because that's unclear at this point. Like when I read the bill, I thought, okay, that's it. But we've also seen correspondence here. Like if the target of this bill is not encrypted data, my suggestion is that we flat out say, for greater clarity, this bill or this part does not imply to encrypted data, and then have a definition. Does that make sense to do something like that?
I think we want to be a bit flexible in relation to when we say encryption. My apologies if the front part of my answer wasn't clear, but there are different types of encryption. So if we say encryption without any qualifiers, then that means that where companies do have keys, where they could decrypt for the purposes of an investigation, where there's a warrant and a production order being provided, that they could, in fact, still use those keys for that purpose.
Right. Okay, so what I'm talking about is a company who's, forgive my vernacular, but their secret sauce is providing an encryption service. Like that is what they do. Company A provides a service that says Terminal 1 to Terminal 2 or Contact 1 to Contact 2, this will be encrypted. That is their business model. What I'm saying is, will C-22 require them to be able to plug into that encryption, decrypt it for law enforcement?
No, if there are no keys and there's no way to decrypt it and that's their business model, then the expectation is that would be a systemic vulnerability for their entirety of their system, to which the answer would be there would have to be some discussion with the government, but the end of it is that we would not force them to put in place into their system a systemic vulnerability.
That is okay. That is exactly what I was looking for. But based on the reading of the bill, and I went through the definition and then through the one definition and then into systemic vulnerability, that wasn't clear to me. So my exhortation is that as officials, that you please turn your minds to this, because I think that there should be something that A, is an encrypted data definition, and B, very clearly says what you just said. A decryption of encrypted data is a systemic vulnerability, or put it right in the definition of systemic vulnerability. I know this is technical. I hope I'm being clear here.
Unfortunately, that may be very clear, but we won't know what Ms. Heigl thinks, because we need to turn to Madame Akan for 6 minutes, please.
Thank you very much, Mr. Chair. Mr. McQuarrie, Ms. Heigl, my questions will be a little bit on the technical side, so I believe you will be answering. As we examine the evolving landscape of public safety and national security, it's essential to clearly understand the role of metadata. The metadata is often described as data about data, and that does not capture the content of communications, but rather provides contextual information such as time, location, duration, origin, or destination of digital interactions. While it differs from content data, the metadata can, in specific circumstances, support analytical insights and help identify patterns that are relevant to the operational needs. So this makes the metadata a valuable operational tool for law enforcement and intelligence agencies, and it plays a critical role in enabling threat detection, risk assessment, and investigative efficiency, particularly in an era where the digital activity is deeply embedded in our daily lives. So please correct me if I was wrong or I missed anything regarding metadata. But given this context, could you please clarify the scope of information that law enforcement would be authorized to access under the legislation, and specifically confirm how metadata is distinguished from the content of communications in practice?
I'll start off the answer, and if you don't mind, I'll also turn it to my colleague, Fenton, and then if you'll give me a few minutes, I'm going to turn it to our CMP and maybe CSIS to provide how important metadata can be in their operations. As you can see within the bill as it currently stands, we have not given a lot of specificity to what elements of metadata we plan on regulating. That's because we need to take the time to assess with our investigative bodies, as well as have an opportunity to speak with industry about the ability to retain various types and for how long. We don't want to, we certainly do not assume that where we note it's up to a period of 1 year, the expectation is not that all metadata points will be kept for up to that 1 year. That's why there's a time period. I would note that we've looked at international comparisons on this front, and we've come in about the middle. Australia holds their metadata for 2 years, where someone like the UK holds it for about a year. There's always a bit of small print there, but generally that's what it is. So through that process, we expect to narrow down what are the very specific types of metadata that are the most important for investigations, and then applying a timeline to that within the regulatory process, which will be able to be, we will do our charter challenge at that point. So Fenton, anything you might like to add?
Thank you. I think the key idea here is we're linking these we're linking the metadata to capabilities that will support law enforcement. So that's how we actually generate and derive what we need. So the whole thing is in that will, as Shannon was saying, we'll be working very directly with the law enforcement and with CSIS to determine what fields and how they support investigations, so that we can basically have a good, strong argument for why that is proportionate, why that's necessary to keep.
Maybe just add, it's Ramsey Nashif, the Director General for Policy at CSIS. So one quick kind of operational point. What we're talking about here is a better understanding of the pattern of communications, essentially. So through regulations, we'll work through the specific details of the types of metadata we'd be capturing. But generally speaking, from our perspective, the reason we would be doing that is to establish patterns of communication in a warranted way to be able to sort of be a building block of an investigation. So obviously there's many other elements, but that's the sort of pattern that we'd be looking for on our side. Thanks.
Thank you very much. So next question could be probably answered again by you or by CSIS. So BLC 22 introduces a new confirmation of service demand authority, and this amendment to CSIS Act is intended to allow authorities to continue obtaining necessary information in support of complex and advanced investigations. My question is, how does this yes or no confirmation of service process introduced in Bill C-22 balance privacy considerations with investigative requirements, and in what way does limiting disclosure to the existence of a service rather than a subscriber identity affect the nature and the scope of information available to law enforcement?
Hi, Rick Burchell, Director General of Technical Investigative Services in the RCMP. The confirmation of service demand is a very, front end at the beginning of an investigation for us to be able to gather basic information to pursue an investigation. So we just have very little information, for instance, a phone number or an IP address. So just that yes/no confirmation from a telecommunications service provider is gives us the ability to verify that, okay, that person is with this company. Now we can start doing investigative work around that to get enough grounds to bring forward a production order to get subscriber information as a next step. But we still have to build those investigative grounds in order to bring forward a production order to get subscriber information from a justice. So that confirmation of service demand is, although there's various ways that law enforcement and intelligence folks are able to get that information traditionally. This codifies that process and makes it disclosable. So we have to document a confirmation of service demand that goes on our file, is disclosed in court, and can be questioned. So we have that reasonable grounds to suspect to ask for the confirmation of service. Once it's obtained, then we still have to build investigative capacity around a production order to go to a justice or a judge.
Thank you very much. Madame de Bellefeuille, pour 6 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Chair. Maybe Ms. Eagle, could you confirm something? The minister said between C2 622 there were consultations of some groups. Could you confirm that the current president, Madame Deschamps, of the Security Intelligence Review Committee was consulted on C22?
Je peux peut-être parler un peu des consultations.
I may talk about consultations. I want a yes or no answer. Was Madame Deschamps consulted on this bill? There were different types of consultations. The minister had meetings with some people, and there were also round tables. To your knowledge, was Ms. Deschamps consulted? That's a simple question. To my knowledge, she wasn't one of those who attended the round tables. So the current president of the current review agency wasn't consulted. So that's what I understand. For the roundtables we organized, that was the case. Don't you find that special that this current president of the Intelligence Review Agency wasn't consulted when we see that elsewhere in other countries that we compare ourselves to, those who are comparable agencies to the Intelligence Review Agencies are consulted? There's a lot of information that contributed to our analysis. There were various consultations, various letters we received from stakeholders. So there were various methods that were used to come up with the various positions from the stakeholders. I am surprised because this is an important agency. She's an important actor. I'm surprised she wasn't consulted. I imagine that you consulted the Privacy Commissioner. You decided to consult the Privacy Commissioner, but not the President of the National Security and Intelligence Review Agency. That is what I understand. We did consult the Privacy Commissioner, but not, yes. Another question to the Department of Justice officials. I'm not a jurist. I've asked this question in the House many times. Why did you choose the lowest threshold for obtaining information? Could you, for example, tell the committee or give us examples? Because for me, reasonable reasons of suspicion, I feel that's a very low threshold. Reasonable ground to believe, I think that is stronger as a threshold. I do not understand why you chose the threshold. Could you give us examples? What could be a reasonable ground of suspicion? I can imagine what is unacceptable. I imagine that all grounds of suspicion is something that is a matter of concern. Could you please give us concrete examples of that?
Merci.
Thank you for the question. That's a very good question indeed. We could give you examples, operational examples. Let me turn to the RCMP. But before that, let me explain why we chose that threshold. It's a legal threshold that exists for other production orders in the Criminal Code targeting specific data, and the thresholds or requirements are lower. For example, content. But could you, for example, tell us, I don't know, maybe the RCMP, you could tell us this would be a reasonable ground for suspicion. And then I would like to see the difference and understand your rationale, if it's possible. Maybe before my colleague gives a concrete example, let me add that reasonable ground for suspicion is not simply a matter of suspicion. We need observable facts, and the officer needs notes before he arrives at the conclusion that there's a reasonable ground for suspicion. And in the tools we have, we also have to established that the information requested will be useful for the investigation. Well, I wanted that. I'm not a jurist. I want to understand better the situation. So send me examples. Now, with the time that is left, I would like to understand something. In the first part of the bill, it applies to telecommunication service providers who, and this has to do with the Telecommunications Act. But in the other part, we are talking about electronic service providers and main providers. In the annex, there's no definition. There are other definitions. So why give this regulatory authority that is so broad in the definitions? Because people are calling us and wondering whether they'll be concerned. Could you please explain to us why there's no definition in the annex? There's nothing. Everything is decided by regulation. I don't know who is going to answer that question. I think that question has to do with Part 2, the new act and the annex. So I'll yield the question to my colleague. That's a question for me.
Vous êtes correct. Il y a juste un
You are right. There's just a definition for electronic service providers.
is purposefully broad.
Okay.
Oh, je m'excuse.
Excuse-moi, c'est parce que votre français, c'est ça, pas... Okay. Allez-y.
Okay.
Go ahead.
C'est juste, c'est une définition très...
It's a very broad definition. It's important because technology is quickly changing. I'm sorry, I have to interrupt. I see that the answer will be long and that your time is up. Maybe we'll come back to that later. Mr. Lord, 5 minutes.
And thank you to the witnesses for being here today. I think I'm going to start with Mr. McGuire. You know, something that I find contradictory in this bill, and maybe you can explain how it's not contradictory, is that you're requiring electronic service providers and telecoms to create the systems to enable the interceptions of communications within their networks. And yet later you say that nothing in this bill seeks to undermine the integrity of encryption networks. Those seem very contradictory to me. In light of the Salt Typhoon hack that we saw in the United States, it was later found that it was exactly the vulnerabilities created by the requirements under U.S. law to create these sort of encryption backdoors that allowed hackers to access this information. So can you tell us, can you explain what this contradiction appears to be?
I'll start quickly and then turn it over to Ms. Heigl. So the intent of Part 2 is to ensure that electronic service providers have the technical capabilities to be able to respond to lawful access requests that are authorized for law enforcement and for CSIS. But Shannon, do you want to?
I'll start off and then I'll flip it over to Fenton as well. So I would say we've taken a look at a multitude of other countries that have this type of legislation put in place, and they have found ways to work with companies and to find ways to pull the information out so that it can be provided to investigations or investigators for their specific investigations. As it relates to I don't feel that there's necessarily a contradiction between the two parts because we are going to set objectives. We, the government, are not going to tell companies or core providers essentially what and how they need to create.
I understand what you're saying there is that the government's not dictating how the companies are doing
Correct.
it, but by mandating the companies to do it in order to comply, companies may have to create vulnerabilities in their system that can be exploited by hackers. Wouldn't you agree?
I would say companies create all sorts of changes within their systems for purposes that they see fit, and we're hoping, we expect through this piece of legislation to find safe ways to maintain their cybersecurity as Canada expects. Canada, first and foremost, puts priority on cybersecurity.
Okay, I'll interrupt you there. If it comes between a choice between a company complying with the legislation or creating a vulnerability that can be exploited by hackers, what is the end goal outcome of the Government of Canada?
I think the expectation is that in consultation with government, we find solutions to this because it is a problem that desperately needs a solution to work with industry and to be able to get information to the investigators to investigate so many crimes now that are going unsolved.
If you can't find a solution, at least in the short term, is it acceptable to the government that telecommunications companies will be forced, in order to comply with the legislation, to create systemic vulnerabilities?
I would say there are partners we already work with right now. So for folks to say there's no way to be able to put solutions in place, I would question that. But Fenton,
I mean, the
anything?
Canadian Chamber of Commerce has said that this legislation is going to force their members to create vulnerabilities in their systems. Like, that's a pretty big stakeholder, including many stakeholders that the Government of Canada works with. This is a big concern. So I just want to clear, if the only way to comply with this legislation is to create systemic vulnerabilities, does the government still think that the companies need to comply with this legislation?
So, Emil, in the sense that we're talking about various capabilities, so it's not like one kind of universal capability. And these capabilities already exist right now. So right now, we in terms of like a lot of the major telecoms, because of the licensing regime, already actually have the capability to address certain requests from law enforcement or CSIS. So what the bill does in that case is basically creates a level playing field for what exists. But if you're looking at a particular application, a particular capability that doesn't exist, if it hits the
About 45 seconds left. So if I can get that in writing from you, please send that in writing. In my last 45 seconds, the Secretary of State for Combating Crime said that many stakeholders are calling this an essential first step and that they need to broaden this legislation. Is the Department of Public Safety working on or envisioning a follow-up piece of legislation to expand the powers given under C-22 at this time?
No, not at this time.
And can you say that the department has done any studies on what the next steps would be should this legislation pass for follow-on legislation in this area?
No, we are very focused on the regulatory step that would follow if we are successful in getting royal assent.
Thank you.
Thank you very much, MP Lloyd. MP Pawlowski, for 5 minutes, please.
So I have a letter before me entitled Joint Call for the Withdrawal of Bill C-22, which is signed by a number of seemingly pretty reputable organizations: British Columbia Civil Liberties Association, the Canadian Association of University Teachers, Canadian Civil Liberties Association, Canadian Council for Refugees. In it, they talk about the enormous overreach of Bill C-22 and the unprecedented open-ended powers it introduced. And then it goes on here, and I'm gonna, because there's one specific provision I want to ask you about, but let me read the whole paragraph. It says, Bill C-22 makes some improvements to Bill C-2's proposal for wide-ranging warrantless access to sensitive subscriber information. The warrantless demand power can now only be used to require telecommunication service providers to confirm if someone is a customer. However, Bill C-22's approach to subscriber data remains flawed, dropping the judicial authorization standard for a warrant from reason to believe to the far lower reason to suspect threshold, despite Supreme Court decisions recognizing the significant privacy interests engaged by this form of data access. So if we're worried about overreach, we're worried about, as they are, mass surveillance of all Canadians, I would kind of agree the reason to suspect seems a very low threshold for accessing potentially personal data. Does somebody want to answer this accusation?
I'll take that question. I think my colleague touched on that and highlighted that there's all sorts of criminal code provisions that use the reasonable grounds to suspect standard. And so in this case, what you're looking at in terms of the subscriber information is essentially a name and an address. And so the balance of that type of information with the privacy concerns reasonable grounds to suspect was chosen as the appropriate standard. And just to speak to your point about, as Spencer, what the decision said was that it was critical that there was lawful authorization. So since 2014, police have been calling for lawful authorization. And so that's what this bill C-22 does, is it provides lawful authorization.
Now, for end-to-end encrypted services like Signal, which I'm currently reading off of, where the providers never possess the unencrypted data nor decryptation keys, these providers would not be expected to degrade their encryption to comply. Is that correct?
That is correct.
Okay. Lastly, you talk about collecting metadata. What sort of metadata? I mean, if I'm on the internet and I'm searching, I'm sympathetic to people of Gaza, and I'm searching about Gaza, and I inadvertently something comes up of Hamas. Am I then? Is there reason for the government to further investigate me because of the possibility I may be somehow doing things to promote a terrorist organization? So, I mean, what sort of metadata are you looking for? And that seems pretty broad, metadata. I mean, that's everything we do. You put it into computer AI and find something on Marcus Pawlowski.
Understandable to be concerned with that. So what I would like to do is just turn it over to my RCMP colleague, who is going to help, along with his team, define what the very specific elements of metadata that are required, and they will be regulated. But for specific examples.
Yeah. So I can give 4 examples of metadata retention that are helpful for law enforcement. Internet transmission data, which includes timestamps, IP addresses, and device identifiers for an investigation. Because as you can appreciate, we don't start an investigation immediately when something happens. When something happens and there's online activity, there generally needs to be a report made, an investigation generated, and if we're looking to get metadata, it has to be a judicial authorization. So we need to have, there's criminality involved and there's victims involved at the front end of this. So by the time we get to the point where we're seeking the metadata is to try to link people to places. So internet transmission data, tower signaling data is also helpful to locate folks if, at a point in time when there's offense happened, or a call, or if it's a kidnapping or something where we need to find a location of somebody that had a vehicle or a phone at a certain time.
I'm sorry, I have to interrupt you abruptly, so we can move to Madame de Bellefeuille pour 2 minutes et demie, s'il vous plaît.
Merci beaucoup. Thank you very much, Chair. In the bill, the Intelligence Commissioner does play an important role. Have you looked into the possible work burden he will have? Have you imagined what will happen at his office with work overload with this bill?
Oui, merci pour la question.
Thank you for the question.
Speak in English. We actually have met with the Intelligence Commissioner himself and his staff to talk about the role once it was approved that he would be the second key. He has spoken to the fact that, and we have given some sense of what we expect to be on an annual basis, how many ministerial orders there may be.
Évaluation de comment vous pensez.
How do you think he will be involved with this bill, C-22? You know, he tabled his annual report, and there was a record number of 14 decisions that were made. So I'm wondering if there will be many more decisions. Are you assessing the number of decisions that the commissioner may have to make?
So his role is specific to the ministerial order approval process. So he will be reviewing all of the information that was given to the minister when the minister made his or her decision on a ministerial order, which is a very specific request to put in place certain capabilities for a company that would not be included in as a core provider.
Donc, Madame Hegel, je m'excuse, le temps court, mais ça veut dire.
Ms. Hegel, I'm sorry, my time is rushing out. So it's exceptional. There are not going to be many. He's not going to be overwhelmed. The Intelligence Commissioner.
Confirm that. We told him, we gave him some initial numbers around what we thought, how many ministerial orders would come to him, and he was sufficiently satisfied that he could manage it.
OK, parfait. Parce que je sais qu'il y a pas.
Great, because I know that there has been no budget increase in his office to help him face the obligations that will flow from Bill C-22. Now, very quickly, you may not have time to answer my question, but why did you not put a clear definition for core provider in Part 2?
For core provider, we do have a definition. What we expect to do is run through the regulatory process where there will be classifications or classes.
Le projet de loi, Madame Hegel, c'est laissé à la.
Sorry, I have to interrupt you. Mr. Caputo, you have 5 minutes.
It's been helpful to have the officials. I mean, one of the things I will say at the outset, I feel like we need 3 hours with you all. This is a highly technical bill, and you know, like I don't say this in jest. Like, we can't rush this. I've got a list of about 8 things I want to ask you about. I'm looking up case law further to Madame Belfay's earlier point about the threshold of reasonable grounds to suspect versus reasonable grounds to believe. I haven't studied reasonable grounds to suspect in years. Reasonable grounds to believe, I'm familiar with the Story decision that it must be, you know, that a person must subjectively believe what they're doing, and that must be objectively reasonable. That probably means nothing to a lot of people, but that's like, this is difficult things to comprehend. So when we're wrapping our heads around this, only having you here for 1 hour prior to clause by clause, I just think it's inadequate. I think we need you here a whole lot more, to be very candid. So I'll leave that with you and with the chair and with my Liberal colleagues, because we have lots of questions. I know I've just burned a minute here, but this is an important question where it comes to the requirement for a electronic service provider to retain data for 1 year. Is that a de facto seizure that runs contrary to Section 8? I understand that a search warrant is required. That would be the search. Normally there's the search and then the seizure, but is the compulsion to retain data itself a seizure?
I'll attempt to just simply say the expectation of the retention by a company, we have not equated that to a seizure within the context of an investigation, because there has been no production order approved by a judge or a warrant. That would be my simple assessment of the scenario. Any of your thoughts?
Yeah, I mean, as far as the like you said, we need a judicial authorization in order to access that data. The timeliness of it is because there's a variety. There are companies that already retain this metadata, and there's not a consistent application of how that happens amongst telecommunication providers, which is what security and law enforcement would look for. But when we're looking to access that data, the reason the timeliness is because if they keep it for 3 days, but you're 1 week into a kidnapping investigation, that data is gone whether you are judicially authorized or not, whereas some companies have it readily available.
No, and I understand that. I'll tell you where I'm coming at this from. In this instance, the state or the government is compelling an action, and that action relates to information over which there is a reasonable expectation of privacy. That's why you need a warrant, right? So the moment you say, provider A, you need to keep this, well, there's a reasonable expectation of privacy over that which must be kept. Is everybody with me so far? Okay, does that not engage Section 8? I might be out to lunch here, but I've been asked this question, so it's something I'm looking to explore.
Just a point of clarity, Section 8 within Part 2 of
Within
the
Part
Act?
2, yes.
Fenton, do you want to jump in?
I think in terms of, obviously we've had discussions around charter statements and stuff about that. I think part of the act, part of the analysis on that point will be how we actually circumscribe our use of metadata, right? In this case, we are not clearly looking, the maximum is 1 year. We're not saying blanket retention, so we would have to basically, in developing the regs and the things that we would have to, in that process, we'd have to prove that they're necessary, the proportion, and within that amount of time. So I think at that point we can sort of come to an understanding of what our charter obligations arise from that.
Okay, so let's go along that line here, because the 1 year is kind of the benchmark. Are you saying, and like we could talk about this for the next 15 minutes. This is, again, very important, and I've got 33 seconds. 1 year is the maximum, is what you're saying. It's not the minimum. It's not just the drop dead date. It's only 1 year. Because to me, obviously any date is arbitrary. Like, why is it a year? Why is it not 9 months? Why is it not 15 months? Why is it not 2 years? Can you offer anything to help out this committee in terms of like why was a year picked?
So as I mentioned earlier, we have done a lot of country comparisons within our analysis, and so 1 year actually was quite common in being the average. Like I said, Australia is on the higher end with the 2 year. We also want to make sure that we're clear on what we are expecting to retain within the metadata context still needs to be defined, and the expectation is that there is some level of rationale as to maybe the metadata of me speaking with Fenton that's really important, because then now I know who is talking to who, would be kept for a year, while something around...
Sorry to interrupt, Madame Heigl. We need to move to MP Housefather for 5 minutes, please.
Le Président, and always fascinating to listen to my colleague, Mr. Caputo. First of all, let me start by saying thank you so much for being here. I'm strongly in favor of this bill. As I said in the House, I think we need a modern access regime. I think we need to deal with Bykowitz and Spencer and have proper legislation that allows us to deal with things like this. But I also had a couple of questions, if it's okay, with respect to the way systemic vulnerabilities interplay in this bill in sections 5.5 and 7.5 of the bill versus sections 12 and 13. So basically what I understand from sections 5 and 7, I think it's 7.5 of the bill, is that a provider is not required to comply if a systemic vulnerability would be created. I think I have that right. But section 12, as I understand it, says that any electronic service provider that is subject to an order made under section 7.1 must comply with it. And then section 13 specifies that orders take primacy over the regulations that will be made. So I don't really understand personally the interplay here, where we're saying that somebody is not required to comply if it creates a systemic vulnerability, but then if there's an order, they're required to comply with it, and then the order supersedes regulations. Can you talk me through this so that I understand how then 5.5 and 7.5 actually work?
Sure, I'll start off and I'll turn to my expert, Fenton, which is we have to consider this as a bit of a continuum where the baseline has to be that you need to, as a core provider, if it's regulation or if you're being tapped through a ministerial order, that you comply with this. Then there is the exception to, and as we go through this process with you to be able to determine how to get that information off of your networks, that it is determined that it is a systemic vulnerability, then there is the right to push back and from our company to push back and say, no, this is not going to, we can't give you the information we need unless because of a systemic vulnerability.
But if we want to say that, why would the bill itself not? I mean, right now we agree that an order is paramount and they must comply with an order, correct?
Yes. Baseline.
So under what circumstances, if the company believes that it would create a systemic vulnerability, is the company then able, unless it convinces the minister or those representatives of the minister to push back and say, no, this would create a systemic vulnerability? How come the bill as drafted doesn't say the order must be complied with, except to the extent that the company believes using reasonable commercial efforts it cannot do this without creating a systemic vulnerability or something like that? If the company believes this, but the minister's office is not accepting that argument, what happens to the company?
Within the context of a ministerial order specifically, I'll stay away from those who are...
I'm only asking about the ministerial order.
Okay. The expectation is that we, public safety would be responsible for actually completing the analysis that the minister considers. Therefore, we intake information from the operating agency that has flagged the issue with the threat that is existing within a company's system. And we actually are required to consult with that particular firm and satisfy a number of factors that are listed in the bill. And then, so as the company is with us through this process, they are able to voice their views. Once we get to the final stage, if the minister then approves the process, the intelligence commissioner has full disclosure of all of the information the minister had, and he also agrees with the process to advance. The company does have the right to a judicial review.
Okay, so at what point, the company is told at that point that the minister, and the commissioner have said they must go forward regardless of their claim. So then they would go to judicial review. What happens until that review is heard? You're saying that there would be a stay on them requiring to carry out the order?
Fenton, would you want to add anything to that?
Yeah. Correct.
Oh, okay, sorry. Was that, you didn't have anything to add?
No, I didn't have anything to add, no.
Okay, I appreciate that.
And unfortunately, there is no more time either.
Sorry.
Thank you, Anthony, MP Housefather, for this intervention. We'll now move to MP Caputo for 5 minutes, please.
Thank you. Okay, I want to pick up on this 1-year retention period. So, if I understand it correctly, let's just say the metadata. I think that's generally what we're talking about here, or whatever is contemplated in Section 2 or Section 5. Whatever, let's just say data here that can be compelled to be kept. My understanding of what was said before was that 1 year is the maximum, and 1 year was chosen because it's like an international standard. There's nothing magic about 1 year, and I understand that every number is arbitrary, but that not everything will be kept for 1 year. I'm clear on that?
Yes, that's correct.
Okay. Correct. So who decides what type of metadata will be kept for, say, well, this type of data only needs to be kept, this is an IP address or whatever. This only needs to be kept for 6 months. Who decides that?
That will be achieved through the regulatory process, for which we will develop analysis with the agencies as to what is the most valuable when it comes to investigative processes, as well as companies. We need to, when we're carrying out the regulatory process, we actually have to consider things like cost of implementing new regulations to an industry. So they would definitely be involved in what it means, whether, as Rick mentioned, sometimes they actually already have that data in their holding, and it's no new delta new cost to them. And in other cases, it might be significant. We need to take the time to be able to do that analysis and come back with a thoughtful scheme.
See, I guess to me that's, on first blush, I have an issue with that, and that is because you have to consider cost. You don't have to you don't have to make your decision based on cost. It is a consideration. But the other issue is that one of the principal discussion points surrounding this bill is how much is left to regulation. I mean, this bill essentially could operate on regulation 90% of it with ministerial orders and things like that. So, I mean, should we not be spelling things out more in the bill when it comes to certainty? You know, if you're a small electronic service provider trying to implement Part 2, are you not shaking right now in terms of thinking, oh my gosh, how much is this going to cost me to comply? Because there is no certainty here with what I'll have to comply with.
So let me tackle that last part of your question right up front, which is core providers are expected to also have go through a process by which we look at considerations of how big they are, how many customers they serve, so that it is unlikely that we would be regulating small business owners and operators through the core provider portion of this bill.
See, again, I go back to my prior point, which is that falls to regulation and it falls to somebody else's decision where there is a consideration about the size and the cost, but ultimately, just because that is considered doesn't mean that that core provider won't have to do what a ministerial order says. Does that make sense?
I understand what you're saying. I think part of why the bill has a higher level of detail than others that you may be thinking of is the fact is this is heavily based in technology, and using terms could be obsolete within a number of years, to which would render the whole bill actually useless. So
I appreciate that. I know that some things have to be left to regulation. My view is in a bill like this, where it could be as prescriptive as possible, it should be, because there is so much here that is left to regulation. So like, for instance, when I'm looking at a ministerial order, every ministerial order, as I see it under section, I believe it was 7, of Part 2, has to be approved by the Intelligence Commissioner. Is that accurate?
that's accurate.
Why not a federal court judge? I get it. They're both presumed independent. I assume the Intelligence Commissioner is presumed independent. Can't imagine why. Both are government appointed, right? Both are presumed to have perfect knowledge, and I think you know what I mean by perfect knowledge. They both presume to have all the knowledge. But a federal court judge is not beholden to the government. They aren't, air quote, hired. Their term isn't renewed, anything like that. They can sit till they're 75. So why not have a federal court judge play the role of gatekeeper rather than the Intelligence Commissioner when there is at least a perception or a reasonable perception of connection to government?
So before I flip it to Fenton, I just want to say within the ministerial order process, we have the Department of Public Safety doing the analysis. We have the minister approving. We do have the Intelligence Commissioner also approving, who is independent and a quasi-judicial oversight body. And then there can be a JR. So we've literally, he's on the judicial side, that's the only entity we've left out.
And I would add at the end of that, we've been Sarah, but I think the Intelligence Commissioner is well versed because he's used, or she is used to doing lots of things like ministerial authorization for CSE, justification framework for CSIS. So they're well versed in these particular issues, right? So they have the knowledge, and from that point, they can actually do that function well.
Thank you. Sorry, MP Caputo. We have run over the time, and we are going to suspend now since we have seen the ministers enter the room. So thank you, officials. Many of you will stay. Et on reprend dans quelques instants.
Where is Thank you, everyone, for coming back. We call the meeting to order again. We want to welcome the two ministers and the officials accompanying them, starting with Minister Gary Ananda Sangari, Minister of Public Safety, and Honorable Sean Fraser, Minister of Justice. You are most welcome, dear ministers. We will start with opening remarks from the Minister of Public Safety, and then we will also hear from the Minister of Justice. Mr. Ananda Gasari, you have the floor.
Merci, Monsieur le Président.
Thank you, Chair.
I would like to first start by acknowledging that we're meeting on the traditional and unceded territory of the Algonquin and Anishinaabe people. Merci pour l'invitation aujourd'hui.
Thank you for inviting me to talk about Bill C-22.
To acknowledge my colleague, the Honorable Sean Fraser. We've been working on this bill for a number of months, and also the officials here to support us. As a Minister of Public Safety, my top priority is to ensure every Canadian remains safe and secure. Since my appointment, I've heard clearly from law enforcement at all levels, municipal police services, and the RCMP, as well as victims groups such as the Canadian Centre for Child Protection. They've all said Canada needs modern tools to take on the wide array of illicit activities that are facilitated by the global digital environment. Technology has fundamentally changed the nature of crime and threats globally. Criminals are continuously exploiting digital space we all use to facilitate a wide array of offenses. This includes extortion, childhood exploitation, auto theft, terrorism, and human trafficking. Furthermore, this environment is being used to facilitate foreign interference and violent extremism. Our laws have simply not kept pace with our digitally driven world. This has created a significant gap between today's crimes and threats and what our current laws can meaningfully address. Nous avons le devoir envers.
We owe it to Canadians to tackle these new threats.
C-22 aims to do. It's worth taking this opportunity to highlight that Bill C-22 does not aim to regulate the Internet, police activity on the Internet, or require Internet service providers to become agents of the government, as some in the debate in the House has suggested. As our officials have confirmed, C-22 is encryption neutral. It is simply to address gaps in our legal framework that present challenges to timely access to information and intelligence that are vital to conducting investigations. It will give our officers the tools they need to keep Canadians safe in the 21st century while ensuring we continue to uphold Canadians' charter and privacy rights. Nous avons écouté les priorités.
We have heard the concerns of stakeholders and other parliamentarians after Bill C-22 was tabled.
22 includes important safeguards, such as limiting the scope of confirmation of service demand to telecommunications service providers, a narrow definition of subscriber information, and strong judicial oversight. Police will still require court approval to obtain personal details like names, addresses, and phone numbers. Under Part 2 of the bill, will ensure electronic service providers can fulfill lawful access requests. Let's be clear. This part does not create new authorities for law enforcement agencies and CSIS to intercept communications or obtain information. Its focus is to ensure electronic service providers are able to comply with existing legal orders, which are found in the Criminal Code and the Canadian Security Intelligence Service Act. Key elements include a new compliance framework that will require core providers to have the technical capability to comply with legal authorization to obtain information such as warrants and production orders. It also gives new ministerial order powers to the Minister of Public Safety. Only with the approval from the Intelligence Commissioner, the Minister could order an electronic service provider to develop specific technical capabilities, for example, to address new technologies that are developed and not captured in the regulations. Finally, it introduces regulatory enforcement tools such as administrative monetary penalties for any provider who does not comply. Mr. Chair, once again, I wish to underscore the safeguards that would be in place under this part of the bill. As I mentioned, all ministerial orders will require prior approval from the Intelligence Commissioner to ensure they're reasonable. This part also includes an explicit safeguard to prevent the introduction of systemic vulnerabilities in electronic protections. Our government does not support the creation of backdoors. We want Canadians to see exactly how these powers are being created and used to ensure their implementation is subject to the highest levels of democratic scrutiny. Under our current laws, our police and intelligence officers are trying to fight tech-savvy criminals and state actors with tools that are decades old. Bill C-22 bridges that gap while it upholds the charter rights and privacy of all Canadians. Merci, et il me fera plaisir de répondre à votre question. Thank you.
Thank you. I look forward to answering your questions.
Ministre.
Thank you, Mr. Minister. Mr. Fraser, you have 5 minutes. Thank you, Chair. Before starting, I would like to thank everyone for being here for this very important debate. It is important to understand the context of this bill, in my opinion. There is a strategy to address public safety, which includes 3 pillars. The first thing is strengthen criminal laws, including C9, C14, C16. At the same time, we recognize that it's not enough to change the criminal code, but we also have to support the people working on the ground in our communities, community organizations, and police officers as well. It's not fair to simply add the number of people working on that, but we need to add more tools to make sure that those people have the capacity to meet expectations.
Of officers who are on the ground. Nous avons besoin aussi de faire des
We also need to carry out investigations to prevent violent crimes in the long term, including affordable housing, medications for people with mental illnesses, support young people with problems.
On that second pillar, supporting those who are on the front lines, trying to make Canada safer every day. And we can't expect people to address modern challenges with outdated technologies. This is where this bill comes in. When we compare Canada to other partners around the world, we are significantly behind when it comes to addressing modern challenges, particularly in a digital context. Technology has changed, the world has changed, and crime has changed. It is faster moving, it crosses borders, and it is digital on an increasing basis. What we've seen with other jurisdictions is they have embraced what we are discussing and calling lawful access. Very simply put, it's the ability of law enforcement to get access to the evidence that they need that may be digital in nature, the same way that we would allow them to get access to evidence that exists in the physical world. You can't arrest an IP address or a phone number. We need to give tools to ensure that law enforcement has the ability to figure out where there is a criminal investigation going on, who is the person behind it, and how can they advance that investigation. When I look at the actual process that we've laid out, I think it's important that we demonstrate to Canadians that we have put in significant thought into ensuring that privacy rights are protected at the same way that we embrace the recommendations of law enforcement to make it easier for them to do their jobs. In particular, to start off, what we're allowing under this legislation is for law enforcement to make a simple request when they have an investigation involving a phone number or an IP address, just to ask, is this on your network, to a service provider? If the network comes back and says, yes, in fact it is, that would allow us to move forward with a process that would be approved by a judge to say, yes, there is a person with a name and an address that's attached to this. Currently, this process can take months. And when we're dealing with people who are involved in criminal organizations, engaging in child sexual exploitation, engaging in drug trafficking and human trafficking, organizing home invasions and auto theft rings, you can appreciate the need to move quickly is essential if we're going to reduce the ultimate consequences of crime to Canadian communities. This bill, in my view, provides the appropriate framework that empowers law enforcement to have the tools they need to keep Canadians safe, but puts protections in place to ensure that where appropriate, judicial authorization remains essential, and to ensure that we put a system in place so service providers actually do hold the information that is going to help facilitate these investigations. If I could perhaps sum it up simply, we are not going to solve Netflix problems with blockbuster technology. We have to join the advanced economies in the world who have been working to solve these problems for many years. And with the support of different parties at this committee, I think we have the potential to send a strong signal to Canadians that when it comes to public safety, we are going to make absolutely sure law enforcement have the tools that they need to keep Canadians safe. Merci, Monsieur le Président.
Merci à vous deux, ce qui nous permet de passer la parole.
Thank you. I'll give the floor to Mr. Caputo for 6 minutes.
Mr. Chair, thank you to the ministers and officials. I'll note that we have 2 Kamloopsians at the table here today, which is always wonderful. Minister Nandasangri, you're off the hook today. We won't be asking you about visa and who gave people from the IRGC a visa. We're going to stick to C-22 here. I want to go into something that you mentioned, Minister. You talked about this is encryption neutral. One of my greatest concerns I'm hearing about is on encryption. And please don't defer to the analyst. What I want to hear your perspective on this. This bill could threaten encrypted communications based on the way it is written, the way some people are reading it. Can you confirm that the purpose of this bill is not to go after end-to-end encryption, as in Party A is using a program to deal with Party B that is encrypted? There's no way to decrypt it. Can you confirm that that is not what is in this bill, nor is it the intent of this bill?
I can confirm that, yes.
Okay. Now, and then to just ensure, like, one step further, nobody, if Company A, there's no requirement for Company A then from point 1 to point 2 to create what some would call a backdoor. I know that that's been to create a mechanism by which that information can be accessed. Is that accurate as well?
And I addressed that in my initial opening.
Okay. If there's any ambiguity on that, I trust you would support an amendment to close that, because this is a game changer when it comes to that bill. I take that to be the case.
So I would say what I told you privately, Mr. Caputo. We brought this bill forward with a number of engagements, including with colleagues in different parties. We will work in collaboration to strengthen the bill. And if there are specific recommendations that this committee comes up with, we will certainly take it under consideration, and we look forward to that engagement to get to the right result.
Now, I'll be blunt, Minister. The Liberal government now has a majority. There is a concern that if there is that room there, that won't be addressed. That's why I'm asking you on the record, if there's a chance that encrypted communications can be targeted by this bill, if that's not the intent of the bill, that's what you said, I don't think it's too much to say, yes, Mr. Caputo, I would support an amendment to ensure that our intent is clear. For instance, an amendment that includes the definition of encrypted data in Part 2, and an amendment that says a systemic vulnerability includes a key to encrypted data, the creation thereof. Like, I don't think that's a difficult one, Minister, with all due respect, to say, yes, that's our intent. Do you not agree?
What I will repeat is that we are willing to work together in collaboration in advancing the bill. I was in the Senate yesterday on Bill C-8. 75% of the amendments that were passed were opposition amendments. They weren't government amendments. On this bill, I think we've been very clear, both of us, that we will work with opposition, as we have on every other bill, to advance and strengthen the bill.
The difference between C-8, though, Minister, if you want to get into C-8, that is exactly my cautionary tale. Just about every amendment that was of consequence, the Liberals voted against. It was the Conservatives and the Bloc that voted for those amendments, that swayed those amendments, with the government often voting against them. Now, things have changed. So with all due respect, C8 is not a great example to use. That's why I'm trying to get it on the record. I think I've made my point. You've made your point. Let's move on. The ministerial order is one of the biggest things. Well, one of them I said was encryption. Another major issue is the degree to which enforcement and definitions are left to regulation. That's one of the primary criticisms of this bill. I look at Section 5, for instance. This is sweeping powers. Section 5(2) sub B, the installation, use, operation, management, assessment, testing, and maintenance of any device. Sub D, the retention of categories of metadata, including that. Now, Minister, I get why the government wants things to be broad, because then you can account for things. But should we not be defining things where we can be defined? Because I'm pretty sure we're going to have experts that say, you know what, we can define categories of metadata. I'm sure we can define categories of metadata. Those don't change every day. Would you be open to an amendment that says, yeah, when we're looking at taking information from people over which there's a high expectation of privacy, I trust you would support an amendment that would define those types of things?
I'm going to just, go back to my initial position, Mr. Caputo. Specific amendments that you propose, we will consider them, and I will personally engage with you on this. However, I don't think preemptively I am going to agree to amendments that you're proposing here, and I'm not going to. It would be irresponsible for me to say I will accept all of these amendments. I think what's important is we look at it, we look at the implications on the bill, and we'll be more than glad to give you our feedback as I've always had.
Thank you for that respectful and useful exchange. Madam Sodi, for 6 minutes, please.
Okay. Thank you, Mr. Speaker. Mr. Speaker. It's been a long day. Thank you, Mr. Chair, and thank you to our ministers for attending before us today. Minister Ananda Sangri, in Brampton, we have seen a concerning rise in crime, any and all types, from car thefts to robbery, to break-and-enters, to murders and shootings in broad daylight. I'm worried about the safety of my constituents and all residents of Brampton, as they are as well. Our Mayor, Patrick Brown, and Peel Regional Police Chiefs have been calling for legislation like Bill C-22 and have welcomed this bill's introduction. With that local context in mind, can you describe the specific threats this bill is designed to respond to and the real-world operational gaps that law enforcement and CSIS face today that Bill C-22 would close?
Thank you, and look, let me acknowledge the work of Peel Regional Police in informing us on the development of this bill. It's been quite critical, and I've had a conversation with Chief Nish Durayap on a number of occasions. This is the #1 priority as indicated by police leaders, not just in Peel, but across Canada at every level, whether it is Commissioner Carrick in Ontario with the OPP or Commissioner Duhem at the RCMP, as well as regional police services. So this is of critical importance. In a granular sense, the technology that we have today is inadequate to deal with the type of issues we're dealing with, primarily telephones, internet, emails, and other electronic devices are used on a day-to-day basis for the execution of crime. Issues of extortion, for example, is oftentimes is by way of a phone call or a text, or sometimes it's by email. And all of these have, over the years, meant a great deal of delay for law enforcement to be able to get the production orders. Oftentimes they'll have to wait weeks, sometimes months, to be able to get the information that will enable them to go to the next step. So essentially what we're doing here, and I use the example of phone directory or Bowers reverse lookup, which can be found at a local library. If you have a phone number, you can go to the Bowers directory, put the phone number in, and you will get the address of the individual who owns the phone number. Right now, oftentimes these are anonymous, so which means that we need to go to the service provider. So if it is a telco, we need to go to the telco and say, is this particular telephone number associated with your service? And it takes sometimes weeks, sometimes months to get that information. What Bill C-22 will do is, as a starting point, will enable law enforcement to get what's called confirmation of service that will say this individual or this phone number is attached to the service that we provide. Once that information is obtained, either a yes or a no, if it's a no, the matter stops there. If it's a yes, then a production order, a warrant will need to be prepared seeking subscriber information on the individual whose phone number may be associated with that telephone company. And based on the warrant, we will get basic subscriber information, which would be name, email address, and so on. Beyond that, any additional information that's required will be back to what we do right now, which is, again, to go back to court, all under judicial authorization, to be able to get the type of information that's required for that investigation to continue. So essentially, it will draw an investigation which could take months into weeks based on the additional provisions that are provided within this bill.
And Minister, you said that you had discussed heavily with Chief Nish from Peel Police. Do you find that this is the consensus that police jurisdictions from all over Canada are wanting Bill C-22?
I would say we've had a number of engagements. So the Honourable Murray Rankin engaged in some mediation sessions and advised us on kind of near consensus. I wouldn't say it was consensus, but it had civil liberties organizations, industry. We had law enforcement as well as community advocates in different conversations. What we have here is an area where I think there's a great deal of understanding and acceptance. You know, it's not perfect. Not everyone is 100% behind this. There are concerns that people continue to express, but by and large, this reflects even law enforcement. We've had to curtail, and you'll see some significant changes in Bill C. 22 that is in C2, for example, narrowing and defining certain aspects of what is included. So we've done an enormous amount of work to build what we think is as close to consensus we can. We won't get full consensus, and I think the work that we need to do is to make sure that all the safeguards are in place. We're fully confident that both privacy and charter concerns are addressed in this bill. Some would like to have us go more. Some would like us not to have a bill whatsoever, and that is not an option for us.
Thank you very much for that, MP Sodi. Madame de Bellefeuille, pour 6 minutes, s'il vous plaît.
Thank you, Chair. Thank you very much, ministers. I don't really have a question for you, Mr. Fraser, but I congratulate you on your French. There's been great improvement. Congratulations on your French. Mr. Minister, the Supporting Authorized Access to Information Act in Part 2 of the bill does not provide for any explicit role for the National Security and Intelligence Review Agency. However, in many of our partners in the Five Eyes community, there's comparable legal access mechanisms accompanied by a formal role for independent oversight. For example, in Australia, the Telecommunications and Other Legislation Amendment Assistance and Access Act provides that the counterpart agency must be notified of the issuance of technical assistance orders. But in Bill C-22, you present a report 1 hour later, an unredacted report 1 year later, and you have, I believe, 90 days to submit that. And it's about 1.5 years after the decision that you would submit the report to CIRA. Why don't you learn from the Five Eyes group and ensure that the agency has a similar strong role as Australia did to the comparable agency there? I would like to understand why.
Merci pour la question, Madame.
Thank you for the question.
Of safeguards that have been built into C-22. So, for example, on ministerial orders, there's a requirement to get acceptance of the Intelligence Commissioner before an order could be issued. There are provisions for a judicial review in certain circumstances. There's also a reference to NCIRA post facto, and this is the ordinary review process.
Je m'excuse de vous interrompre.
I'm sorry for interrupting you. I read that. I did my homework. What I want to understand is why is NCIRA somewhat ignored, in my opinion? I know that the Intelligence Commissioner has a role. Why not notify the agency in real time? Because it's being done about 1.5 years later. Why don't you want to make sure that the RCMP and the related agencies comply with the law? I proposed an amendment to make sure that NCIRA be notified in real time. Copying from Australia, I consider that it's a guarantee. It's the trust we are giving the government to make sure that the surveillance agency, whose primary role is to carry out reviews, and why are they not notified? I was surprised that Ms. Deschamps, who is the president of the National Security and Intelligence Review Agency, wasn't consulted on Bill C-22. So sincerely, in my opinion, it makes no sense. We are learning from the Five Eyes when it comes to best practices, but no important, significant role was accorded to the agency in Bill C-22. Why not notify the NCIRA in real time?
I would say in part, in order to move forward on a ministerial order, the timeline for it to go through the NCIRA review process could be quite significant. So it is a safeguard that's built in. The role of the Intelligence Commissioner, as you're aware, there's a lot more real-time responses and the ability of the Intelligence Commissioner to give that feedback. So there is that safeguard is there, so the Intelligence Commissioner could, approve or not approve a proposed order.
Qu'est-ce qui empêche de notifier l'office? C'est ça que je comprends.
Why not notify the agency? I don't understand why you're excluding them. That's their primary mission, to review, and you are setting them aside. You only inform them 1 year after the fact. I'm repeating my question. I will present the amendment. I know that you were open in the House of Commons. You were open to amendments. So for me, it's not complicated that you don't notify the Office of the President of NCIRA. Just like Australia, you seem to resist this fact. Do you have any arguments against my amendment?
I did meet with both the Intelligence Commissioner as well as the Privacy Commissioner as well as the chair of NCIRA. So there's been a number of engagements that I have done on my personal level and on top of the engagement that our departments have undertaken. What I would say is that we don't believe that NCIRA can provide in a timely manner the required acceptance or rejection of a particular ministerial order, just given in some cases the urgency of the matter. That's why the Intelligence Commissioner is being utilized in this regard. The role of NCIRA is always as a review, post facto review agency, and this legislation is in line with the way NCIRA is currently operational, which is to review matters and to report back on potential errors, potential omissions.
Juste pour vous interrompre, Monsieur le Ministre, vous savez.
Sorry to interrupt you. You know that the presidency, the president of that office, is not in agreement with their interpretation. She informed members that she felt that should be notified or informed at least when there are ministerial orders. She should be informed at the same time as the commissioner. So I think it's important that the agency play a greater role to gain the trust of the public. That's my opinion. Thank you very much, Madame de Bellefeuille. Madame Kirkland, 5 minutes.
Thank you, Chair. Ministers, I appreciate you being here, and I appreciate what you say about supporting our frontline officers. The call for lawful access has been one that's been called for a lot of years. I do think, though, we have to be careful, and we have to be careful not to rush something through. We need to get it right, and we need to balance our duty as parliamentarians, our duty of care, that we are protecting the privacy of Canadians. So my questions will be based on that. I think we have to be careful not to race to royal assent. We have to do this right. More than a decade ago, actually, I don't know if you're aware of this, but your party warned against a bill very similar to this, a lawful access bill. They said it risked turning Canada into a surveillance state. Today, you are advancing similar powers, but actually in a more expansive form with Bill C-22. In fact, Minister Francis Scarpelleja, who is our current Speaker of the House, but at the time was the Liberal public safety critic, warned that similar lawful access legislation, in his words, risked creating an Orwellian service state. So my question to you is, was he wrong?
I will say that successive governments have failed to advance lawful access as a very important tool and framework that is required.
Yeah, I'm aware that I'll interrupt you. I'm aware that it has failed to continue. My question is, has the Liberal government changed their position than what they had over a decade ago, or do you believe that Mr. Scarpelleja was incorrect at that time?
I mean, this is not about Mr. Scarpelleja, Ms. Kirkland. Like, this is about the safety and security of Canadians. As you're aware, Canada's new government, under Prime Minister Mark Carney, undertook to ensure that, as Mr. Fraser aptly outlined, the three pillars.
Okay.
And this is a very important part of that pillar.
I'm going to
maybe
move on.
Sean could add.
I'm going to get to questions for Mr. Fraser momentarily. Minister Anana Sangri, can you give any assurances that this legislation, as it is written, will not be used in ways to go beyond original intent? I've heard department officials say the bill is not intended to do X, Y, Z. However, if the bill allows the government to do those things, what is to prevent a future government who maybe has a different approach to privacy and civil liberties than you from abusing that power?
I will say a lot of thought has been put into ensuring that the safeguards are in place, both from a privacy perspective, but also to ensure that it is charter compliant. So we are very confident that the bill, as presented, does have those safeguards.
Okay, so at the time, over a decade ago when we tried this before, there were warnings that rushing complex surveillance laws without properly gauging Canadians' views could lead to failure. You mentioned that you were very confident that privacy and safety is addressed in the bill as it is currently. Your government relied on consultations led by Murray Rankin to inform Bill C-22, yet you have not released that report. Will you release Mr. Rankin's report and share it with this committee?
I would say that Mr. Rankin's report, and I'm grateful for the work that he has done, it was prepared. He's a lawyer. We're both colleagues. It is presented to me, and I've used, and Mr. Fraser has used it through me to inform our decision. This is the bill right now is not about Mr. Rankin's report. So what I would say is,
sir, I just wanted to ask: is that a no? Then you will not release the report to the committee,
I'm seeking
yes,
privilege. I'm seeking privilege on that matter, and
so,
I don't believe that will be released.
Over a decade ago, the Liberal government warned that government rhetoric shut down meaningful debate on that iteration, Bill C-30's lawful access provisions. Yet today, this committee is being asked to study similar powers without access to the consultation report that informed how to proceed with lawful access reform in Bill C-22. That report is essential to any meaningful scrutiny and Parliament's ability to do its basic legislative function. By withholding it, your government is effectively asking MPs to approve legislation without full disclosure of the evidence behind it. So why are you, sir, refusing to release this report while insisting we move forward with these powers?
I would say,
Why are you insisting?
Well, if I may answer.
Thank you. I want you to just answer that question.
Well, you had a preamble. I should be able to give you a wholesome response. So if I may, what I would say is that as a normal course of bringing a bill forward, there are a number of different pieces of information that a department relies on to develop the legislation and getting the requisite authorities in order to bring forward legislation. Vast majority of the time, none of this information is disclosed. That is part of the decision-making of the government. You're welcome, Ms. Kirkland.
Merci, Monsieur le Ministre. Désolé, sorry to interrupt both of you. But we now need to turn to MP Casey for 5 minutes, please.
Thank you very much, Mr. Chair. I was in Parliament the day that Francis Scarpaleggia went after Vic Taves with respect to the lawful access legislation at the time. And I distinctly remember Minister Taves saying, "You're with the government or you're with the child pornographers." And I remember the proliferation of the hashtag #TellVicEverything. Because there was a widespread perception at the time that the legislation was an overreach. And right across the country, there were people that were providing Minister Taves with information about spilling soup on their tie because they felt that perhaps Vic was interested in everything with the measures that he was taking to trample privacy and the over-the-top rhetoric that was being used at the time to support it. I'd like to bring Minister Fraser into the conversation. Minister, in your opening remarks, you talked about the protection of privacy and compliance with the Charter in that regard. And I know Minister Anandarangasi Ananda Sangari. Yes. I'm sorry, Minister. Perhaps I'll just call you Minister. Hopefully we won't get confused because there's two of you there. Mr. Fraser, can you talk a bit more about the protection of privacy and the compliance with Charter and the efforts that have been made in this legislation to do the two?
Yeah, and look, maybe just to help us get there, I want to provide a little bit of context. I know Ms. Kirkland, when she led her questions, talked about this debate going for a few years. It hasn't just been going for a few years, it's been going for 30. I would invite everybody to watch the video of Commissioner Carrique's summary of the importance of this bill upon the legislation being tabled. You can hear the frustration that is coming out of law enforcement, and I do think there is a consensus amongst law enforcement to move forward because they are very tired of criminal organizations responsible for human trafficking, for auto thefts, for drug trafficking, to know that there's this activity going on and to be trying to do their job with one hand tied behind their back. And when they're receiving tips from foreign governments in particular on something as sensitive as child sexual exploitation, they want to move. They do not want to invade people's privacy along the way, but thankfully we have had several evolutions in Canada and around the world that have demonstrated how we can better protect privacy. There's been some discussion at this committee about the differences between Five Eyes partners and Canada's approach. Of our Five Eyes partners, or France or Germany or Finland or Spain for that matter, none of them require judicial authorization in order to get subscriber information. We're talking about information that used to be in the phone book, and we're still requiring that a court actually approves access to that information. This is going to streamline access without compromising privacy in any significant way. If you want to go beyond that, even in exigent circumstances, the one exception where there is an emergency playing out where a crime could be stopped or evidence is going to be destroyed, there's even the opportunity on the back end. The test still has to be met, but the harm can be undone, so to speak, by a court excluding evidence, should they need to, if in fact there was a privacy breach committed. Every step of the way, we've improved this, by the way, through the consultation process with different MPs from different parties and with experts who have said, you know what, you might actually want to ring fence what subscriber information you're looking for. So we have excluded medical information. We have excluded legal advice. This is about finding who is behind a phone number or IP address that we expect is tied to a criminal activity of one kind or another. At every step of the way, we tried to give law enforcement the tools they need to combat modern crime, but at every step of the way, we said, how are we going to do this in a manner that respects the reasonable expectation to privacy, which is protected by the Canadian Charter of Rights and Freedoms? I'm convinced that we found the right balance after many years of debate, many months of discussion amongst parliamentarians of different parties, that strikes a balance that will allow us to defend the interests of Canadians, keep our communities safe, and respect the privacy rights of Canadians at the same time.
Minister Ananda Sangari, do you have anything that you'd like to build on based on that answer that you just heard?
I think Mr. Fraser has captured the work that we've done and also the urgency. What I do want to underscore is as technology develops, and we know that we're already 30 years behind in this work, as technology develops with AI, with other tools at a scale and speed that, I don't think our world is quite ready for. The need for lawful access framework within Canada is so essential, at the very minimum to keep us to date and to evolve as new technology emerges.
Thank you very much for that. Madame de Bellefeuille, pour 2 minutes et demie, s'il vous plaît.
Thank you very much, Chair. Mr. Minister, you confirmed to Mr. Caputo is that the intention of C-22 is not to allow for the creation of backdoors in encrypted systems, either now or in the future. Now, when we studied C-8 on the same issue, on the possible weakening of encryption, Minister Joly, responding to the question I put to her, said even though there was an intention expressed, she accepted to clearly include in the bill an article saying that there will be no decryption. Now, when it comes to decryption, this is a widespread fear. Maybe you can reassure the population by including in the bill an article or an amendment that clearly says that the encryption system will not be compromised. Do you believe that it's possible to further clarify your intention? Because when you were responding to Mr. Caputo, you clearly stated that was not your intention. Could you please further clarify this in the bill? Is there room for that?
Look, as I've indicated prior, I will, we will look at every amendment. There is an amendment-making process, so once you complete the work, there'll be recommendations that comes forward from the committee. The undertaking that I can give you is that we will look at every single one of those proposals, and we will give you the feedback. As always, I will engage with you. I will engage with Mr. Caputo and others as well who want to advance on this issue. So that's the commitment I can make to you today.
Sans vous interrompre, mais à votre place.
In your place, when Minister Joly appeared before the committee, she committed to add an amendment that was tabled by the government party to add the fact that there will be no decryption. This is something she clearly stated during the study of Bill C-8. I'm asking you the same question. Are you ready to ask your team to find a way of adding to the bill certainty that will reassure the public that the encryption systems will not be undermined?
Madam, I've worked with you very closely now for almost a year, and I think you generally know the approach that I've taken as in collaboration. So I will certainly be willing to meet with you and look at the proposal you have. Anything to strengthen the bill, we would be more than glad to entertain.
Merci, Madame de Bellefeuille. Le député Lloyd pour 5 minutes, s'il vous plaît.
Thank you, Mr. Chair. Thank you to the ministers for being here. Minister, you've refused to waive privilege on the report provided by Murray Rankin on the consultative process in this report. I've been told that this report has been widely shared with people who participated in the consultation. I'm assuming the fact that those people who have not shared the report have done so because they signed a non-disclosure clause. Can you confirm if the members of the consultation had to sign a non-disclosure clause in order to get access to the report?
Mr. Lloyd, I'm not sure if they did or not, but what I will say is that the conversation today is not about Mr. Rankin's report. It is about the bill that is in front of the House. And there is no precedent for governments to be sharing information that was gathered, discussions that took place to committee. I think we're really sidestepping what the real core issue that we're here to discuss, which is the bill itself.
Thank you. I've given you enough time on that, Minister. This report was critical in your government coming up with the report. And so I think, as members of Parliament, it would be very helpful for us to have access to this report. I think it's critical that governments try to build trust with Canadians. And I have to admit, what it looks like what you're doing here, Minister, is not accountable. It's not showing transparency, especially when we're dealing with very contentious legislation that deals with the privacy rights of Canadians. What are you hiding, Minister? Why are you refusing to share this report?
You're welcome to call Mr. Rankin to the committee, and he will be able to provide information. But what I will say is that what is happening right now is a bit of a distraction of what the core issue is, which is discussion on the bill itself.
Minister, you're making it a distraction by refusing to reveal the report. The very fact that we're talking about it today, even people who receive the report, people who support C-22, people who are against C-22, they're baffled of why this report hasn't been revealed. It's becoming a distraction because you're making it a distraction, Minister. Why not just reveal the report?
The matter is not about the report, Mr. Lloyd. You know this. This is about the bill itself. The bill is presented by myself and Mr. Fraser. If you have specific questions about the bill, I will be more than willing to answer, but I'm not willing to answer you on privileged information that I believe I sought from Mr. Rankin, which informed our decisions. But there's also a number of other individuals that I met, Mr. Fraser met. We consult people on a range of people on developing a bill.
Why should the Minister, I've given you plenty of time to respond. Why should the stakeholders who participated, the Canadian Civil Liberties Association, other stakeholders, why do they have more of a right to see what is in this report than members of Parliament who are being asked to vote on this legislation?
So I will, as I said, if you would like to invite Mr. Rankin to testify, you're more than welcome to do so.
Okay, I'm going to move on, Minister. I was talking to your officials before. There seems to be a contradiction. The legislation says it's not intended to weaken encryption or create systemic vulnerabilities, and yet there's other parts of the legislation that are saying a ministerial order is intended to create the very technical capabilities in order to get through this encryption. So I ask, if the outcomes desired by this legislation, that being lawful access, cannot be accessed without creating systemic vulnerabilities, will your government still order telecoms providers and other ESPs to create these encryption capabilities?
As I said initially, this bill is encryption neutral. It does not envision and it does not anticipate breaking of encryption in any way. What I will say, the ministerial orders, as contemplated, will require the Intelligence Commissioner to approve, which is part of, I think, the safeguard that's in place right now.
In response to my question during debate regarding compensation for providers, you were pretty blunt. You said, as a condition of CRTC licensing, you expect companies to comply without compensation. Is that an accurate depiction of what you said in the House?
What I will say is...
was it accurate, yes or no? Sorry.
Mr. Lloyd, I don't recall. But okay. I will say that I have commented on this, so I can...
And you're saying no to compensation, just be clear.
What I will say is that this bill... there is a world in which compensation is possible, but my view is that companies that are operating in Canada are good corporate citizens. Five Eyes countries do not necessarily pay.
So that's very different from the answer you gave in the House. What situations do you think compensation could be provided?
I would say at this point, I don't anticipate any particular situation, but if there are extenuating circumstances where a company's financial position may be limiting, that is a one-off consideration, but by and large, we do not anticipate compensation to be provided.
Thank you, MP Lloyd. MP Akan for 5 minutes, please.
Thank you, Mr. Chair. I want to share some technical considerations regarding metadata for my colleagues to consider before proposing amendments that could significantly affect the effectiveness of this bill. Modern criminal investigations, especially those involving child exploitation, human trafficking, extortion, organized crime, and cybercrime, rely heavily on digital metadata to reconstruct events, identify suspects, and map complex networks. These cases are often reported long after they occur, making historical data essential for establishing timelines and connections that are not immediately obvious. It is therefore potentially risky to narrow the types of the data retained. Different metadata types serve different investigative and IT functions. As such, attribution, communication mapping, and cross-platform activity reconstruction. If key categories are excluded, it can break the chain of evidence and limit the ability to link activity across systems and jurisdictions. From an investigative and digital forensic perspective, missing metadata reduces the ability to conduct pattern and network analysis, which is central to modern intelligence-led policing and cyber investigations. It can also weaken evidentiary completeness in court. Many serious crimes are reported long after they occur. If certain metadata categories were never stored in the first place, they cannot be recovered later, even with a warrant or court order. Mr. Chair, I ask my colleagues to please refer to this transcript of my remarks when considering any amendments related to narrowing the types of metadata or limiting the retention periods, as these changes could significantly weaken the effectiveness of lawful access. My colleague, Mr. Caputo, raised his concerns regarding not only the types of metadata, but also the 12-month data retention framework outlined in Part 2. While during my meetings with the law enforcement officials, they have clarified the general parameters, there remains a practical challenge when it comes to complex investigations. Many serious cases, such as child exploitation, human trafficking, organized crime, and extortion, are inherently time-intensive and often extended well beyond 6 or even 9 months due to their cross-jurisdictional and digital nature. So could CSIS or the RCMP elaborate on the operational importance of data retention in supporting these type of complex investigations, and significantly, how does the availability and duration of retained data impact the ability of the law enforcement to conduct true, timely, and effective investigations in the digital context? Thank you.
Ministers are gesturing to me, so I'll take that as my cue. Can give 2 examples, perhaps. So one example could be that CSIS is trying to determine the movements of a terrorist group, and we've received a warrant to track a person of interest cell phone. The electronic service provider did not have the necessary capabilities to track the device. So we're out of luck if there's not the capabilities to track the device. And so that is one of the key capabilities that would be provided under Part 2, because it would require ESPs to develop and maintain location tracking capabilities that are, quite frankly, standard in Five Eyes and in European countries. Another example could be that we receive information from a foreign partner who's carrying out an investigation outside of Canada where a few of the subjects of investigation are associated with a Canadian phone number. And the foreign partner has further highlighted that that threat looks like it's about to move into Canada. We're able to confirm that the phone numbers were obtained through a reseller, but the reseller quite frequently does not maintain records of its sales nor track its clients' activities. And Part 2 would bring that into play by having the resellers brought into the process and allow us to be able to respond to those types of requests.
Do I still have time? 30 seconds. Okay. Bill C-22 makes an important legislative change clarifying that, actually, it's not going to be enough, Mr. Chair. I'm okay with that.
Mr. Chair, if
Thank you. Thank you.
if there's 20 seconds
I
left,
don't want to get clips of that, but Minister, do you want to add something?
Ian, look, there are now 15 seconds left. If I can just add, these are not fictional crimes. If you actually talk to law enforcement officials, particularly on the second example, A lot of people don't appreciate this. Law enforcement in Canada is receiving an ungodly number of tips of potential threats, including child sexual exploitation. The application of the laws is inconsistent as between provinces because it's unclear about the regime on how we actually use digital evidence to investigate
I'm sorry
and
to have
prevent
to
crime.
cut off
These are real threats.
ministerial colleague, but it's over, unfortunately. And having said that, merci beaucoup au ministre d'avoir.
Thank you, ministers, for taking the time to prepare and come here before. Thank you, officials, for doing the necessary work. We will suspend. We will adjourn now. See you on Thursday for other work. Thank you. Meeting adjourned.